Good afternoon, everyone. It is a pleasure to be here at IBDT. I was very happy to have friends around me, and we also have our guest speaker, Mr. Brownie, with us. And I risk to say that it is impossible not to have mentioned Professor Schrader here and also his work while we discuss uh, transfer pricing. Now, in terms of the topic today, options realistically available and country risk and other controversies, it is important to understand that with this concept is not limited to tax law when we consider transfer pricing. Its concept can also be found in regulatory law and international commercial law, competition law, so environmental law too. So it is present in many other scopes. And in a very simplistic manner, what we have is when one party in a transaction, you can ask, would they have a viable alternative that could have been taken differently from the one that is taken? If yes, this alternative could have generated more advantageous conditions if done with a third party, or not if we have achieved. I would like to share with you an experience that I've had by discussing aura and this in the BAPA context. It was a bilateral agreement signed by two mature countries. So it was an operation in which most part of the discussion was around options realistically available. And the topic was on the table for discussion before the other topics to be discussed for 12 months. So these are two nations that are mature in this discussion. And the taxpayer won in their arguments. So now they're making adjustments. But this topic was really something very controversial. I learned several things from this discussion. Number one, subjectivity. Subjectiveness. So determine what is an option realistically available, and this is highly subjective. Any stakeholder will have a different perspective of this if there is any option available. And evidence collection. So proving what is an option realistically available, and frequently it requires an extensive economic analysis, market information, and expert opinion. And economic feasibility, it can be technically available but not feasible in terms of economic wise. So this is another option and something that also is present in this discussion. There is a law also, something that is legal or not legally viable here in Brazil, but may be feasible in other country. And other problems is the time sensitiveness. Discussing aura within the context of APA or BAPA means that you're discussing something contemporary. Discussing aura in tax landscape in 2008 when the IRS asked, why did you not do this back then in 2008? This changes the history of everything. So, what I would like to hear from our panelists is how can we just find a balance and can we combine the rules of general of anti-avoidance rule when there are no limitants or no constraints, and when the IRS can also limit the tax based on aura, and the ADIN and Article 16 of CTN that addresses this issue. And if there are any other aura requirement that should be more focused on APA and BPA and so on. So these are the inputs that I would like to leave with you for comments. And then in the second part of this panel, we have the country risk. I would like to congratulate IRS for establishing an annex in which they include an example, and it was very well worded and said that if feasible, if appropriate, apply country risk principle. In practice, every day I am asked that question. So I do the math with country risk or not, and my answer is, can you really apply it? And I've seen taxpayers saying, I'm including country of risk because it's more conservative. But this is not the issue. So we should also analyze the situation or examine the situations in light of this concept. So I'll pass the floor to Carolina for the moderation. First, good afternoon, everyone. I would like to thank for the opportunity to be here in this panel with so many great guest speakers and experts. I would like to thank for this invitation, especially Luis Flavio and Professor Schroeder and Professor Maito. First, I would like to pass the floor to Professor Browner. So he will be speaking about the perspective of the U.S. and also he's going to bring us some practical or some hands-on experiences with this.
All right. Hi, everybody. It's our honor to be after lunch. And so we need to talk about some exciting stuff. And I think controversies are exciting, so long as transfer pricing could be exciting. And I want to speak about three different types of controversies that you can see in the slide. But I want to start with some, I guess, academic comments that I have about some transfer pricing fundamentals and, in my view, a misunderstanding of some of the fundamentals that lead to a lot of these controversies. So I believe today, for the most part, transfer pricing is exactly, or the transfer pricing practitioner is exactly in the position of this picture. We have a lot of trees, we have a lot of sophistication in the application of the rules, but I wonder if after 60 years of guidance in this area, we actually see the forest, or even more importantly, find our way out of this forest. So in this context, I want to start and ask the question about the purpose of the rules. And bear with me, it will sound in the beginning, I assume, a little bit simplistic, and may also not be, we may not all be in agreement on this. So first of all, what is the purpose of international tax law? International law generally is about having peaceful relationship between states, and international tax law is all about facilitating international investment in a peaceful manner, and in the context of cross-border investment. And transfer pricing is part of this story, and its purpose is to facilitate the clear reflection, and this is I'm taking from the United States rules, but it's the same everywhere, clear reflection of income when markets do not control the income or the pricing. This is not an economic norm. This is a purely legal and political norm, right? In a world without borders, we would not need transfer pricing. We would have some kind of international taxation of firms. We acknowledge that firms work cross-border, et cetera, et cetera. This most people understand. However, in the practical sense, especially in cases around the world, in treatises, in practice, et cetera, everybody talks about arm's length. And even today, we've heard arm's length principle. Well, guys, there is no arm's length principle. A legal principle has to be based on some fundamental understanding, moral, whatever it is. The arm's length is a standard of application of the transfer pricing norm that, again, it's a purely legal political norm. It is universally adopted, as we all know, and it is also limited in scope. Even the OECD admitted that it doesn't solve all of the problems as we've seen. Now, the application of arm's length has been well known throughout the world, sort of universal. By the way, I will admit I am biased. I am not an arm's length supporter. Maybe I'm an arm's length fool in the, in the quote of Luis Flavio, because I'm pessimistic about whether that's the right way to approach it, but whatever. The application of arm's length, however, has changed dramatically, especially with the BEPS project and the 2015 transfer pricing guideline. Some people have written about the new arm's length principle, where more and more elements of recharacterization were inserted into the rules, especially the guidelines. And there was a deviation from the traditional focus on pricing, on valuation of non-market transaction. Now, this is a really difficult question, because how can you do, theoretically, even the easy cases, pricing of non-market transaction based on market transaction without doing something about the characters? How do you separate these anti-avoidance rule or anti-abuse rules from pricing rules, right? But the norms of transfer pricing, I think anywhere in the world, do not provide any solution to this conundrum, to this difficulties. There's no hierarchy, and the guidance is actually very confused in the context. Courts have been traditionally reluctant to allow recharacterization. However, the transfer pricing guidelines since 2015, and also some US, I guess, guidance, make things a little bit more complex in this context. So, as I said, there is no arm's length principle, and you can see my little picture that I think speaks for itself. This shift started about 20-something years ago with the OECD one day changed the wording in the transfer pricing guidelines from a standard to a principle. Why people, whenever I ask this question, people answer me, well, it's not a big difference. Well, in legal jurisprudence, there's a huge difference between principles and standards. Now, a lot of tax cases are based on this idea of arm's length, it's tax parity, neutrality between related party transactions and non-related party transactions, all of that. So let's ask ourselves, what is the value there? I mean, I can think about generally two types of justifications. By the way, none of these justifications are reflected in the legislative history of any of these rules. One justification could be an efficiency justification. So assuming that related firms that are organized in a hierarchical manner, multinationals, are competing with firms that do not organize themselves that way, that operate in contracts, in market transactions. And you want to have neutrality between these two. Well, guess what? Our current transfer pricing rules do not do that. Plus, it's an empirical question that has not been discussed. It's actually a very nuanced and difficult to explore empirical question, because sometimes there is substitution, sometimes there's no substitution. At the end of the day, the decision to operate in a hierarchy is a rational decision. That's the assumption under the market theory. So we cannot say that people are just making decisions because of whatever. And it's different in different industries. The other potential justification is a fairness type of justification. We have to treat equally two different firms. Well, first, the firm is not treated anyway. It's people that are being affected, and I have never seen any serious study of what are the philosophical justification for that. In reality, we don't see it in the legislative history of any of these rules. So I challenge this idea. Now, you can say just tautology, but I think there's a lot of important ramification for this confusion, and the things that we're going to discuss today will show that. So, of course, we do that because we prefer certainty. We prefer things that seems very simple. Okay, let's treat non-market transaction as market transaction. The market is the know-alls, and therefore we can rely on this algorithmic element. The problem is, and I'm not sure, I was looking from far away, I was not sure you can read this, but I think this is a good quote of Warren Buffett that says, if I subscribe to the efficient market theory, I would still be delivering papers. One of the richest people in the world. And I think this reliance on arm's length in this context and the way that the reliance occurs is to blame with a lot of these problems, because we don't think about the norms, but rather we have this path dependence to go and follow the market, and when we cannot follow the market, we do adjustments and analogies, and we forget where we actually started, what was the original purpose. So I'm going to skip to options realistically available. This idea had some US origins. The wording is slightly different in the United States, but it doesn't matter that much. The original appearance of this term was in early transfer pricing regulation in the 60s, where the government really struggled with implementing certain substance over form analysis that they tried to do. They essentially lost all of these transfer pricing cases, despite the fact that they had a legal, rather an open legal provision that looked very much, and still looks very much, like a general anti-abuse rules. So the commissioner, the IRS, may intervene and recharacterize the transaction, the income, and the deduction, and the credit, whatever, for the purposes of clearly reflected income when this is necessary. Now, for years, there was no mention of ORA, let's say, right? And still, by the way, very few cases even mention it, and when they mention it, they never really analyze it specifically as part of the regulation. The next step is the 1994 regulation. Again, here the issue was mainly to balance the flexibility of the best method rule, right? Because in the United States, you have all of these methods, and you can choose based on the availability of data, but of course it gives the taxpayer a lot of power in this context. So they try to use the realistically alternative terminology to balance that. We see later multiple attempts to codify what happens, this language in the regulation, and one of them, during the Obama administration, wanted to codify even worse, in my opinion, that the valuation under transfer pricing has to show the highest and best use. So not just realistic available option, but the highest and best use. But note, however, the difference. Here we're talking about pure valuation. We're not talking about recharacterization. And still the regulation and the code are not clear what they really mean beyond dogmatic talk. And we have several options. One is to help us in valuation. This is traditional arm's length standard application. Second, recharacterization of transaction. So simple case, I am the parent, I have a subsidiary and in a different country, and I give it a license, non-exclusive license for 1 year, but I don't give anybody else a license. What does that mean? Should I do that? Shouldn't I do it? Should I give license for 20 years? Should I give license that says exclusive? All of that stuff. Finally, some people interpreted this as a change in the burden of proof, in fact. So the idea behind it is to say, well, normally in transfer pricing, you take a position, the government can come and say, we'll challenge your maybe comparables, whatever it is, your choice. But here, with the ORA, you need to show that you did this analysis, all right? So it effectively changes the burden of proof in these cases. This all developed into what we find today in the transfer pricing guideline, which is more relevant, unfortunately, I would say, in Brazil. Interestingly, in 1993, the OECD produces a document where it strongly criticized this language in the US regulation, because they said it's subjective, and I'm not getting into that because I know that Professor Schuel is going to get into that. He was kind enough to share his slides with me, so we will prevent duplication. But then, out of the blue, in 1995, the transfer pricing guidelines show mentions of these words without an explanation in only 3 places in the comparability part. The context was the bargaining powers of the parties. Those of you who practice transfer pricing know that the thinking about bargaining power is kind of tricky because you know, there is no bargaining power because the parent and subsidiary, are you doing a one-sided analysis, a two-sided analysis? These are classic transfer pricing debates that I will not mention. However, we have a lot of cases that actually struggled with this problem. We even have cases where they said, look, the subsidiary has the factory, and therefore they have a lot of power because they're the only ones that can produce the particular product. But of course, who put the factory in that particular jurisdiction? That was Singapore in the original case called Sandstrand in the United States. So, you know, the analysis is somewhat limited from an intellectual perspective. Anyway, this has proliferated into 80 mentions in the 2022 transfer pricing guidelines of this term. And we can find it now in the general arm's length standard discussion, in the intangible part, in the services part, in business restructuring, in the United States, in the cost-sharing context. And there's obviously some domestic law impact, and we've discussed Brazil today and separately. So the transfer pricing guidelines focus was on this idea of best method. So on one hand, you give a lot of freedom to the taxpayer, but on the other hand, you need things to balance them. So kind of little anti-abuse elements in the system. But there is no, if you read the transfer pricing guideline, with all the respect to you practitioners, you cannot put it in a computer and do anything with it. You know, you need a lot of interpretation because it has a lot of elements in it that you can pick, you know, one section or one paragraph. But if you look at the entire set of guidance, it's impossible to get to a clear, obvious result. There is no weight given, for example, to realistically available option. And that really matters because if this is an unspecified method, by the way, that's how it used to be thought of in the United States originally, then, okay, maybe that's what you use. But if it's just one of different consideration, what would be the weight that you give to this? And there's absolutely no guidance. The transfer pricing guidelines say, for example, that your decision will be informed by options realistically available. What does that mean even? If we go to the theory, and our chair described it quite quickly, we're talking about rational choice, the homo economicus theory. Again, Professor Schuel, I'm sure, will elaborate on that. And so on its face, it looks simple, especially in the easy cases. What are the easy cases? Where you can do X or Y, and you choose the one that has less tax on it. But for easy cases, we don't need the transfer pricing rules. We can use, you know, simple interpretation of regular tax, income tax provisions. The other place where you see a lot of mention of ORA is when a company could decide not to do what they are trying to do. So not open that factory in the foreign low tax jurisdiction. Again, if this were a clearly better options, this is the language of the transfer pricing regulation, then we don't need this rule. These are easy, as I said, cases. The problem are the difficult cases, right? And we can find ourselves in a situation where we don't know what exactly is the purpose of the rule, how much, for example, recharacterization is permitted in this context, and primarily the matter of risk is not treated in a way that any person could come and simply read it and implement, let's say, these rules. So if we're talking about the general issues, I'm not sure we need this language. Is this language adding confusion, or is it really adding any real added value or changes anything? If it's recharacterization, then I have a problem. Because what happens, a regular anti-abuse rule that allows the government to recharacterize a transaction usually will have a very strong burden of proof on the government when they apply the anti-abuse rules, right? I think this is true throughout the world in different versions. Whereas in this case, through the back door of transfer pricing, if the government can use it in this manner, this changes the entire structure of tax law. And transfer pricing is important. I mean, related party transactions are a large part of cross-border investment, right, in the end of the day. This is particularly problematic when we try to do it in two specific situations. And here, obviously, I also criticize arm's length more generally. One is when there are no options. So if you engage in a transaction that no unrelated parties would enter into it, it's too risky, obviously. But you control some of the risk because you operate in a hierarchy, right? You control, competition risk, you control inventory risk, you control a bunch of other risks. This doesn't give you an answer to this situation. And the other problem is what happens if my strike price is at a level that no unrelated party would engage in it. But on the other hand, I'm going to use Natalia's metaphor of the body. The body can tolerate limping a little bit if it's going to take it over the finish line. And every business has this, economies of scale that are very difficult, and maybe synergy issues that are very difficult to separate, especially in the new economy. And I think that saying that these transactions are not economically viable is not satisfactory, because the reality is that these are pretty good decisions for these companies. Now, I'm not going to spend much time here, but the question is, what is best? All right? What is realistic? What is available in this context? These are very difficult interpretation challenges. I think if we think about it, let's compare that to corporate governance, for example. When management of a corporation takes a decision in the context of government, a lot of countries use the best judgment rule. Wouldn't that serve as the best, in this context? Don't we have tools to control business decisions in a way that will be less burdensome and elaborate? Now, of course, these rules bring a lot of money to you guys, so we have to realize that. But you're all also citizens of your state, and you usually tax people would like to have a more rational tax system. So maybe I'll stop here on this. The second topic that I want to talk about is country or locational risks. The origin of this debate came from emerging economies that thought pretty simply that resident states are trying to allocate profits away from source, right? We all know that this is what happens, and therefore the transfer pricing guidelines traditionally would not allow you to take into account some fundamental elements that real businesses take into account when they make a decision to operate in a particular country. If you decide whether you want to penetrate the Chinese market, of course you take into account the very specific features of the Chinese market. Same thing for Brazil, same thing for any other country. So The 2012 TP manual of the UN included this, and the TPG responded in 2015 in a defensive way. What did they say? Well, it cannot be a separate intangible because you don't want to have this profit attraction. And it requires rather a complex and long analysis that tries to eliminate as much as possible the special domestic characteristic, despite the fact that it allows this fact and circumstances analysis in the end of the day. The UN, in comparison, still does not stress this issue of local comparable because, as you probably know now in Brazil, when you adopt the TPG, it's very difficult to find sufficient local comparables if you didn't have to do it before, right? A lot of countries, I've had a good example from Vietnam, for example, when it was a communist economy, kind of opened up. The government bought some databases from Japan to do in comparison to their domestic transaction, which is ridiculous, right, from a theoretical perspective. So this led to a bunch of rules, and I know you can't see it. These are the US regulations that are trying to be, I guess, a little bit more fair, at least in my view, than the transfer pricing guideline. And they limit this only to significant issues that impact the competitive positions of buyers and sellers in the market. So you see, it is colored by this tax parity argument rather than the simple analysis of the evaluation of income and evaluation of unrelated party transaction. And they hang on, this is the transfer pricing guidelines. In Chapter 9, the business restructuring chapter, they rely on the realistic option analysis in the analysis of locational savings. So again, we have multiplicity of really vague concepts where there is no, in my view, satisfactory guidance. The final topic that I want to mention is the blocked income. It's a recent, this is the most US part of my analysis. We've had two really big cases involving Brazil of situations where there was a parent in the United States, a subsidiary in Brazil, and Brazil limited the ability of the subsidiary to distribute royalties. You know the background better than I. It's not just tax law, it's also other regulatory measures. In the United States, the IRS decided in a regulation to limit the ability of taxpayers to argue blocked income. So let's say the 3M example, they were able to distribute a royalty of 1%, and the parties stipulated, agreed that it should have been 6%, whatever, right? And the question becomes whether they have income. That is the real question in this context. And the court ruled for the government, but it relied on a regulation and hundreds of pages of historical analysis that really has zero weight in any serious discussion. But that regulation relied primarily on the idea that the foreign legal restrictions should apply to market and non-market transaction alike, so general applicability, which is kind of ridiculous, right? Why would Brazil provide limitation on certain transaction beyond exchange controls in market transaction? Market transaction, if you believe in the market, which most countries kind of believe, you don't need this restriction. Where is the abuse potential when you have non-market related party transactions? And because in this particular case, the Brazilian restriction was only for non-market transaction, the court ruled that this income is not blocked. There are some additional details. I'm going to skip this. I'll only just say that the Coca-Cola case, which is the second case beyond 3M, was a very weird case because the Brazilian subsidiary, instead of distributing a royalty, didn't distribute any royalty, but it distributed dividends, and it called them in lieu of the royalty, right? And they distributed at the level that would have been restricted, at the level of the restriction of the Brazilian authority. But then the government comes and said, look, if you distribute dividends, you could have distributed more dividends, which is true from an accounting perspective. So the judge said, well, it's not about the character of the income, it's about the amount. So just about the pricing. And therefore, you're going to be taxed. And this is a case that's probably the largest tax payment ever in the world in this case. So, but this raises a serious problem again. If our system is based on specific treatment or specific types of income, could we just exchange them seemingly? I mean, dividends can bring a lot of things like foreign tax credits. There could be deductions for royalties, but no deduction for dividends. So there's a lot of complexity in this context, including in the treaty context. Thank you very much.
Queria agradecer ao professor Brauner, acho que ele já trouxe uma bela demonstração ali de como vai ser, né, o futuro aqui para o Brasil, como isso tem sido visto lá fora e o que a gente pode esperar ali, inclusive em termos de contencioso. A seguir, eu passo a palavra para o professor Chueri fazer a exposição dele sobre o tema também.
Obrigado, Carolina, Marcelo, companheiro de mesa. Senhoras, senhores, também eu preciso dizer bem-vindos aqui, que bom estar com todos aqui. E é muito bom falar depois do professor Yariv Brauner, porque o conteúdo já foi, então é só falar alguma coisa depois disso que já está tudo esgotado. E realmente eu queria tratar dessa questão das opções realisticamente disponíveis com uma perspectiva um pouquinho diferente, discutir se isso está de acordo com a nossa ideia de legalidade, Cláudia. A parte histórica, o Yariv já mencionou, esse bicho começa a aparecer lá nos Estados Unidos. Em 93, nós encontramos alguma coisa como the construction of alternative business could prove to be arbitrary. Ou seja, aqui nós temos uma visão ainda dos Estados Unidos dizendo não dá para a gente ficar inventando. Nós não podemos, ou seja, nós temos que nos basear em realidade, não constructive. Gente, 93. Eu lembro de 93. Em 95, a OCDE começa a falar um pouquinho diferente, fala assim, olha, eu tenho que levar em conta a possibilidade de existirem também alternativas economicamente viáveis, disponíveis. Em 2010, nós temos uma mudança bastante grande, não é mais levar em conta, a OCDE passa a falar que empresas independentes, quando vão tomar uma decisão sobre os termos de uma transação em potencial, normalmente comparam a sua transação com outras opções realisticamente disponíveis. Opa, já mudou o comportamento. Então, o empresário sempre considera e compara a sua transação com outras. E, finalmente, chegamos ao nosso brinde 2022, dizendo que todos os métodos que aplicam o arm's length devem ser tão ligados a essa ideia desse ora para nós, gente, essas opções realisticamente disponíveis, todas sempre aplicam o método, sempre considerando as opções realisticamente disponíveis, sempre considero. Então, houve uma mudança na própria linguagem da OCDE. Mas aí vem a questão, por que opções realisticamente disponíveis? O professor Yariv Brauner já mencionou, existe uma racionalidade econômica, parte-se de uma figurinha chamada Homo economicus. O Homo economicus é um cara extremamente racional, que só pensa em si mesmo, então ele sempre vai buscar querer ganhar vantagem em tudo, ou seja, tudo vale em relação ao seu bolso. Então, empresas independentes só fazem um negócio se forem ganhar o máximo possível, porque, afinal de contas, esse é o raciocínio do Homo econômico. Existe uma racionalidade por trás, racional. Um homem racional só age de acordo com o seu bolso. Essa é a premissa que vai...
Wallets. This is the assumption that will justify order. No one is expected to act differently if not by thinking on their wallets. And then we have the first question. Do you think this is true? Do you think being rational is something according with your own wallet, do you think our system, the current one, we talk a lot ESG, do you think companies decide only based on their wallets? If I have a constitution that sets forth an ideal solidarity, Natalia, I ask, when you decide, Natalia, Natalia has a social entity where she's a participate. It is example what she does personally as ESG. According to your view and OECD view, you're not rational because it's not rational to dedicate yourself to the society you live in and thinking solidarity. Less rational is to be homo economical. This is the view, the assumption. No reasoning out of homo economicus.
The question is, can these apply to companies? Do they make decisions that would not favor them in terms of benefits, but they also understand themselves as being part of a society and they have a commitment to that society? So they make decisions based on the society and not because they're going to be more profitable in that transaction. So this is a matter of foundation. So here we have the options realistically available. So we have already worked with some complex expressions like the arm's length. Arm's length is also something that is imprecise. But anyway, you can understand what is behind the arm's length principle. Now, options realistically available shows a problem that should be clear. It's not in the singular form. It's not to be best. Dr. Browner, I wish the policymaker would have the best, because it's not the best, it's just other options. So this is the following. The lieutenant comes to sergeant and says, get me 5 soldiers of your preference. And then he chooses 5 of them and come here. And then they cannot discuss what he has done. There is no control on that because they are 5 soldiers selected as random. Now, if you give an order like this, Sergeant, so get your 5 best soldiers for this mission. Then things change. If the best ones, even though it is abstract because there is an indeterminate concept, you can also say, I'm sorry, how have you chosen A if you have B, which is more skilled to that? So you can have a way to justify that. It's different from just pick the 5 soldiers and the 5 best soldiers. Do not find the best solution, the best alternative. Even though it is not the best one, we don't even have that. We just have any transaction that the tax authority wants to apply to this according to our legal text. So the question is this compatible with legality? Nobody, I hope, nobody here was just going to just focus only on this. But let's assume that legality as a principle requires us to find the best determined term for that. So this determination is based on the principle, and this is included in this expression, meaning there are several auras. So the policymaker does not give us any guidance on which options they will be. What are the criteria to be taken into account when you find an option and for which you can replace those aura? Because I mentioned the case of Elon Musk. I would say, what is an option realistically possible for you to take man to Mars? There is nothing rational to that, and Elon Musk decided to do something like that. So let's replace. No, instead of using bringing man to Mars, so the option is to take man to Spain. So, because it's arbitrary, right? Because I cannot just convince Elon Musk saying that, well, this is really crazy. He will do that anyway. He's stubborn for that. So options realistically available is something that is totally uncertain. I'm just saying here that this is an environment that is totally uncertain. This means that the policymaker allows that the tax authority chooses any alternative that they want to put in that provision. And then you have just to accept that. There is no criterion for that. There is no outcome that is determinable. So this is very open. And I don't find that this is according to the rules because you have the center of decision based on the policymaker. And so he is authorizing you to take any alternative he wishes out of millions of alternatives available, saying that it's just available. And I'm not saying that they are, but there may be other alternatives. So the policymaker just gives us a guide, say which is the aura that will replace the one that effectively is chosen. And I do have a problem with the legality, even though we are very open minded, but I think that this is a big thing. So, in concluding, I think that vagueness is very big, very broad. I agree with legality, but in that uncertainty in terms of concept has a limit. And my limit is when I cannot judge anything because of whatever choice or whatever option you choose, the judge will say, well, this is realistically available. Either one, there is no control of that in terms of the legal law. And this, I think that this is really beyond what is acceptable to me. The policymakers should give at least say what is the closest, applying the best criterion, or the one that is closest to the transaction that occurred. But this is not in our tax, so this is why I don't like it. Thank you. Congratulations to Professor Schroeder. I think that he brings a very clear perspective of his thought, and I think that we all agree, or many of us here agree with him. Now I would like to pass the floor to Professor Renata Emery for her comments. I would like to thank everyone here. We have this big and beautiful audience and this main ballroom. I'm very honored to be a member of this panel together with Professor Schroeder and Professor Browner, two of the most important tax lawyers of our times. And I also have here my dear colleagues like Carolina, Fabiana, Gustavo, and Marcelo. It's an honor to be here. I would like to thank ABDT for the invitation to be here, especially Professor Gustavo Neto, Rodrigo Maiton, and Professor Schroeder. It's very difficult to speak after these big titans of international tax law, especially after Schroeder spoke, or he said something that I will also going to say. But I'm trying just to make comments on what has been said. I would say that Article 8 of Law 14596, regulated by 10 and 19th of Normative Instruction the 261 of 2023, actually has granted broad powers to the tax authorities to conclude that non-related parties, when they act in business transactions that are comparable and reasonably commercially available. So if you consider the options realistically available, and if they don't have this operation or transaction taking place, the tax authorities can simply do not consider that operation and replace it for another option that is considered realistically available. In a nutshell, what Article 8 did was, as Professor Schroeder said very well, they just gave this power to deconsider my operation as a taxpayer, including in terms of denying recharacterization of that operation to another one, and simply, well, even though this is not a simulation of fraud, which is important to consider, so the fact is just because, according to the tax authority, there should be an alternative that is more available and is more favorable. So If the tax authority identifies that there is an option that they consider to be more favorable, then they are authorized to apply to the decharacterization of the operation. And to me, this give rises to two problems, as Professor Schroeder said. The first one is a matter of unconstitutionality. How can we just choose an option that is realistically available according to the principle of Article 170 of the Constitution? So there's a different thought compared to Schroeder. So the freedom in the contract is protected by economic freedom. This is the principle of economic freedom, which is also something that agrees with other principles and assurances that are in our constitution, like freedom and Article 15, or like the right to do something based on the law, which is Article 2nd, and the freedom to exercise your profession and work, or paragraph 3 of Article 5. So this means that how can we coordinate all of this with the possibility of the tax authority to replace a decision of the administration and to replace that decision for them, for the one that they have made, with to be because which is based on an option that is realistically available. So this has to do with the freedom to have economic freedom and freedom of the contract, and it is not compatible with the legal certainty, and also in terms of typical characterization, which has to do with the principle of legality as was addressed. So how can something that is so broad and undetermined, according to the aura, can really comply with all these constitutional provisions when there is a high level of subjectiveness? Because this allows the authority that enforces the law, so they can consider the situation according to their own experience or personal experience, which can vary from one person to the other. So this is why the norm can be enforced by two different people in two different ways, and this may lead to something that is arbitrary. I'm just going to give you an example. So assume that a client wants to hire Schroeder for an opinion, major professor, one of the authorities of tax law in Brazil, and of course the price will not be cheap. Then the tax authority comes and say, well, um, no, you do have an aura. You can hire Renata. Okay, tax authority may think that because Renata also works with international tax law, and she's also a professor at IBDT. So, in the judgment of a tax authority, this may be an option realistically available, even though it is not an option to us, but for the tax authority, it is. Now, with this silly example, we can see the extent of subjectiveness that is behind the norm, and it depends on the judgment of the one who is enforcing that law in situations that are not really compatible with the reality. Fortunately, Schroeder, you have no client that is related party in this case, so this is why we don't have this situation. But the possibility of the tax authority to replace the administration of or management of the company based on this reflection or input without considering all the other multiple factors that usually I take into account when you make a decision shows to what extent that this kind of rule may bring legal uncertainty, and how this can also violate the principle of trust and also typicity. So there is a high level of uncertainty when you use this norm because the concept is undetermined. The second issue raised here has to do with legitimacy of this. Now I'm going to connect this with what was raised by Marcelo. The legitimacy of considering certain legal business out of the field of simulation of fraud. Let's recap. Paragraph single of CTN is only authorized the tax authority to not consider acts of legal businesses that have been practiced by the taxpayer with the purpose of simulating the generating factor or other elements that are part of this transaction to be taxed. As we know, the Superior Court of Justice, when considering this, also and examine the constitutionality of this provision, consider it constitutional. However, it made it clear that this norm is not anti-avoidance norm. It can only apply to tax evasion. And then the STF was very clear when it said that only acts of legal businesses with intention of simulating or deceiving anything that is under the law, you can enforce a normal paragraph or the sole paragraph, which has not been regulated by the Superior Court of Justice, STF. This means that for the STF, the acts that can be unconsidered are the ones that are fraud and simulation. And what we see here, according to the legislation of transfer pricing, which was very much highlighted by Professor Schroeder, is the possibility of tax authority to consider any business where there is an aura involved that to be more advantageous, even though there is no sign of fraud or simulation. This means that, according to the ordinary law, you moving beyond the circumstance that complementary law authorized and gave power to the tax authority to unconsider these acts. So, because of this reasoning, I understand that this norm is unconstitutional, is illegal, and it violates sole paragraph of article of the CTN. So, after these comments, I would like to pass the floor back to Carolina.
Obrigada, Renata.
Thank you, Renata. So I think that we had a very good closing on the aura topic. We have some other topics to discuss, but I think that we have a very good panel, and I think that we have very good inputs for you to consider and study. And of course, we're also going to spend more time on this. And now, to talk a little bit about the country risk topic, I would like to pass the floor to Professor Fabiana. She'll be speaking from the Tribune.
Dói o pescoço daí, né? Bom.
Well, good afternoon. I'm so happy to be in this place. It's so nice to be talking with you, and especially before professors and friends from IBDT. I would like to especially thank Luis Flávio, Rodrigo Maita, and Professor Schwery for inviting me to be here with you today. You are my professors and your friends. I have no doubt about the friendship that brought me here, but also I have no doubt that I'm here because of what I've learned and keep on learning with you during our debates and what we disagree, Professor Schwery. How many things we disagree during debates or in the benches of the faculty and made me grow so much. Perhaps here I would disagree a bit about the inconstitutionality of ORA, but uh, details of ORA is not the purpose of my speech today. But I had a my mission is to talk of country risk. And Katarina asked me to address is country risk, but always trying to put within the context in the light of what was spoken previously here regarding fitting this new law in the ideas and determined concepts. Possible, not possible. Discretionary, is it possible or no? So leeway, so said in the table previous to this, it was we have migrated from a system of words that are strict import, export, goods, services, rights, interests to a more open notion. What is the purpose of this new control? To have a controlled transaction where I have to analyze the commercial and financial relationships of the parties in any arrangement or contract. So see the distinction of the words here. We exit a list that is straightforward regarding related parties and we go towards a concept that we call it as more economic in the influence and the expressions and business with a list that is just an example. So we leave fixed margins for one that's without pre-established margins. We exit the methods choice except for commodities method that was mandatory for a regime and system of choosing a method, but not any method, the method that it's more adequate or fit for use. So we leave rigidity and went to indeterminate concepts. We left objectivity and we go to vagueness, polysemy. We abandon practicability in a large scale and we open space for leeway. Any problem regarding this in my reading? No. At first, no. In practice, maybe. Therefore, why discretionarity? When we think about it, we bear in mind the ideas of concepts of value. Concepts that are opened, allowing me to have more than one option, more than one choice. Any choice? No, of course not. The choice that will be satisfactory. And what happens? We can have more than one choice. Therefore, the law sets forth not only being that subjective, but delivers many adverbs, adjectives, mode and intensity adjectives, commerciality, regional transactions, economically significant risks, assumptions, highly uncertain, and uncertainties that are reasonably foreseeable, options that are realistically available, and characteristics or circumstances that economically significant. What does this all mean? It's openness that might provide a space for choices, or more than one choice, in fact, allowing to be leeway or discretionality. Professor Schwery mentioned this. Perhaps he did not mention the word discretionality, but he talked about the legal system controlling. When you have discretionality, the legal control is reduced, but less space for this control. It's there, but less. But the importance of these circles is that the words and expressions, naturally, they have a semantic core that's minimum. I cannot detach for this minimum semantic core. So we have within the circle what I call a certainty zone with right options in it. And outside of it are options that certainly are out. But what happens between the positive and negative? You have a dark zone, and within the gray zone is where we will have doubts regarding applicability of this legislation. We all know we have a first step for enforcing these new rules, that we will see the limit of transactions. So the starting point is the analysis of the contract wording. So this is I will call of a substance analysis, because the text is the starting point but not necessarily the arrival point. So I must analyze text construing the substance of the business. What's the substance of the business? Understanding the legal cause of the business. So how to do this is what's preached by OECD and regarding and our civil code regarding the construal interpretation of our business. But I must see the text, but the intention of parties, and also analyze how the parties behave and what is in fact what the contract is saying. I have to see good faith. I have to see the reasoning, commercial reasoning of the contract. I consider what is reasonable regarding that type of negotiation that is ruled by the contract. So I migrate from the substantial analysis and go to the functional, economic, and looking risk, function, jobs, risks and rights, goods, services that are being transacted, looking economic circumstances of the business, and looking also the business strategies are taken into account also. And still within transactions, the options are realistically available. I will not talk, we talked exhaustively about this previously, what was placed in all talks by open teachers. Options, choices. Which one? One? Perhaps some scenarios we have one. Other different scenarios we have many choices. Which one I can choose, the exercise can choose, when they have a range of possibilities, all possible or all reasonable. I have space for leeway discretionality. I choose some of them. I exit this part and now go to comparability analysis. According to OECD, it's the core of arm's length. And here we have an economic analysis with some objective criteria: transaction date, price uncertainties, available information, group synergy, and important economic characteristics. So, characteristics: economically significant and information available to reach the subject of country risk. In which context we have country risk? In the identification of comparable transactions and comparability analysis, I compare the control transaction with a comparable one between independent parties. So what's set for by the normative instruction aligned with what is set by the OECD? Start from a domestic comparable. This, why this? Why geographic issues regarding location might impact the price. Therefore, we'll try to look a domestic comparable. But if we don't have a domestic comparable, if it's not reliable or not fit for that transaction, look for one that's not domestic from a different geography. So here we have the first point regarding doubt or problem. What comparable non-domestic? Where? Closest region geographically wise. So Brazil will have to try to find someone in Latin America or even North America. We'll not go to Asia or Europe. Professor Natalia mentioned during this morning that in Colombia, the excise has used comparables from China, a faraway place, right? So, and what about the inland revenue? Here have praised the work of the RF, and they deserve being recognized for their service, because they do not oblige some adjustments to be done in the comparability analysis, and also does not oblige when we deal with country risks. But where it says, but when you identify material differences in margins and prices do the adjustment of comparability. Within these adjustments, market adjustment might include the country risk. And what is country risk? The idea is linked to the fact that I conduct business in a different place with economic and financial uncertainties like war, unstable currency, and no rule of law being applied, the judiciary which is slow and stable, and therefore this will bring and pose risks. My business is affected more by these risks, so we will expect for a higher return on investment. It happens, but one is know of the possible risk. So this idea that I can have more risk, more payback, it's always this ratio, no. And now, was for OECD, developing countries, they must normally resort to comparables that are not domestic. There's not enough information about local entities that will deliver information for the purpose of comparability. It's not something that's automatic. Judgment is always required when we have this situation. An interview conducted by the OECD with some representatives of some countries in 2016. What was found? Australia avoids making country risk adjustments. South Africa resort to non-domestic comparable because they don't have it, and most of the time they do country risk adjustment. Colombia in 2016 uses comparables non-domestic. Professor Natalia just mentioned it uses the excise say the time that we use there was a time usually use USA and Canadian compare, but today Natalia said they use a lot of China, and back then they avoided to do risk country adjustment due to the uncertainties regarding its enforcement. Canada use USA comparables, tries to make adjustments but recognizes the difficulty of this adjustment. Mexico also faced difficulties finding comparable. It used for economic and financial wise closed markets, India and Malaysia, but generally resorts to USA and Canada, and they have to do when necessary the adjustments. In order for the study of Mexican consultants, they refer to the American norm that indicates a formula. So I calculate the country risk using I apply a rate EMBI published by JP Morgan, which is a rate related to public instruments. Is it automatic if the consultants do it? No, these consultants, they do a research analyzing the industrial sector and identify during comparability that extends within the industry, identifying the locality of entities do not have a data that is consistent that will show that the higher risk country it does affect profitability. Therefore, these professors pose doubt the use of these rates. Furthermore, be careful in the indiscriminated use of these rates might eliminate competitive advantage, like as an example, labor cost reduced producing in Mexico, removing competitiveness when I compare with Mexico with state. So now the inland revenue has an attachment, provided an example, and say, do when necessary. It's not always. It's not mandatory. And there's a formula different from the Mexican formula. I consider assets and working capital. So the formula here that Marcelo confirmed is the formula do mandará. I don't know what this means, but this is the formula. But it worked very well because it's a possible method. It's not a mandatory method. It only if there's an important difference between price and margin. Here I wrap up my talk, and when adopting, I don't know, the industry perhaps make more sense. Different countries, perhaps this was not influenced that much environmental issues that affect this regarding geography, political, financial, economical. So financial operations now perhaps make more sense. Which rate to enforce? Based on what? Leeway. Again, there's only one base, there's only one rate. No, at the discretion of the person who chooses to do low reduced control. So we are in the gray zone. Transfer price legislation, it's a labyrinth, very difficult, that leads you to one exit. According to transfer pricing legislation, I might reach more than one way out. It might be multiple exits, and here resides the danger. But at first, I don't see inconstitutionality. Thank you very much.
Fabiana.
Thank you, Professor Fabiana. This mission was not a simple one, but you concluded brilliantly, presenting all the issues related to the rate country risk. Now I pass the floor to Professor Gustavo Haddad, who will talk about the controversial aspects regarding the enforcement in the practical side regarding transfer prices that I believe to be something very important that has raised doubt on those who apply it. So you have the floor. Good afternoon. Thank you. First, I thank Professor Schwery, Luis Flávio, Maito for the invitation to be here again with all of you, and thank my peers in this table, professors and peers I admire so much, and the attendees in a typical São Paulo afternoon, which is hot. Carol asked me to identify other issues. The title of our panel, Order, Risk, Country and Other Issues. And I chose to talk about intertemporal issues which are afflicting me in 2024 related to the migration of a regime with format like Fabiano and the previous panel. They explained the format with prefixed margins, privileging being practical, privilege the simplicity for a format that searches for catered for the standard arm's length, involving more subjectivity and more discretionary aspect. So intertemporal issues that when you change the regime, you have a transaction that it's done and supported by the previous regime, but it's producing effects throughout the timeline. So our trend as tax lawyers, we say, well, the future effects already happening under the governance of the future legislation. So the principal retroactivity rule of the conditioning circumstance does not support us in order to maintain the previous regime if the effect deduction of expenses, taxing on revenue will be happening under the governance of the new law. But studying concrete scenarios and situations, it seems to me that we need this make a distinction amongst them about the choices of the previous legislation and the current one. So this is what I will be addressing in a brief talk. Well, briefly, in a nutshell, in order that our countries of the other countries, the new transfer price became effective and enforceable during 2024, it was possible for the voluntary early adopters last year, 2023, but we have this shift of regime to formulate practicability and fixed margins for a new regime that was talked a lot by the previous panel as of 2024. What I will face here using two cases, practical cases, how to deal with transactions before the new law, but with effect on tax calculation basis as of the governance of the new law. Transactions that might happen on a daily basis of many of those here with us today. The legislative reference in order to digress on this debate, the slides are in English, but I will talk about it in Portuguese. But according to the law, 14596, the provision most important in addition to the effectiveness date is the Article 9 that establishes what, according to the transfer price analysis, is the comparability analysis. Fabiano talked about this analysis. Article 9 sets forth that it considers the date of the transaction comparing with other transactions done at that moment. But here we have a first temporal reference for the moment the transfer pricing test, which when you do the transaction. This is the only temporal um, reference for common law, the normative instruction of RF, those peers from here, they introduced, they participated. The normative instruction repeats this guideline and also sets forth in Article 73 what it's natural to set forth, saying that this new law is applicable for transactions done before but with effect later. We should address here what is the extension of this enforcement of the new law for a transaction that took place under the anterior regime. And for this purpose, I brought two cases that are emblematic, that happens on a daily basis, and based on them, let's try to establish what would be the momentum that it's relevant to establish what is the applicable law for transfer pricing test. The first case, very simple. A, so a company borrowed money in 22-23 for a term of 5-10 years that will have interest expenses, and part of the interest expense under the previous law and part under the new law. So this is the first case for this borrowing. And the first case of the import of a machine under the previous law, by which the taxpayer chose the previous law to apply the PRL method, resale minus method, that implies the execution of fit to use test according to transfer price legislation to each a certain period.
I will briefly speak about these two cases. Now, in order to speak of them, it is important to consider some notions that, in my view, let us know how we must see the situation. The first one is a rule that we know, which is the non-retroactivity. It is new and only applicable to new generating factors. And applying this rule establishes that when you use interest rate incurred from the 24th should be taxed under the new law. However, the protection against this retro taxation rule, you also have the ineffectiveness of the legal certitude. There are legal situations that have already been protected under the previous legislation that should be respected, even though, according to the typical view of the rule of retroactivity, which is Professor Scherzel own taxable event, even though it does not protect that, the principle of legal certainty can be applied if it is considered to be so. We're going to give you two examples. So the more I think of this situation for transfer pricing, there is another conflict that arises. Should I apply the law in the moment when it is meant for the test of transfer pricing, or based on the generating factor? In the case of transfer pricing, what is the moment that is relevant for you to determine the law that will rule that test? So that is ultimately that is affected by the two cases. Now, speaking of interest expenses, so there is a loan that is taken under the previous law. So the previous law establishes the following. According to the tradition of prefixed margins, it says that interest paid could not exceed the fixed rate that was the rate of the Brazilian sovereign rates at the moment when the operation was hired, but with a spread that also applies there. So If there is a mutual operation that has an interest rate that was established according to this criterion, so this rate would be accepted throughout the period of this loan agreement. And this is explicit in Article 9 or paragraph 9, so that the test of the interest rate would occur at the moment when the operation happens. And it goes beyond that. If there is any amendment made or any change on the conditions of that loan agreement, so this was considered a new operation and a new test to run. Now, under the new legislation of price transfer or transfer pricing establishes other criteria. It adopts comparatively sector level of indebtedness to determine what is the interest rate that will be fit to that operation, to that loan operation. But it also chooses as the moment for test the one when the financing operation took place. This is the normative instruction, the guidelines of OECD, and in the law. The question here is this loan agreement which was signed in 2022. So the interest rate was prefixed, established in the law 9430. Now we have a new law that established a new criteria to establish the adequate interest rate. And the taxpayer should go back in time and then redo the test that was done in 2022 and also apply the new law means that you require the taxpayer to go back 2 or 3 years and then do recalculate the interest rate on that moment by using the criteria of the new law. I have difficulty in accepting the situation because the interest expense dates back to January 2022. But the previous law just prioritizes the test to be run under the predetermined rate at that moment back in 2022. And the new law could not go back in time and require a new test to be run. And other criteria in the legislation will be applicable if it is established that the period should be every quarter and adjustment should be made this or that way. All the other effects will be applicable. But requiring to go back in time for you to do a test that has already been consolidated under the previous regime in a situation in which the law required the test and also assume that to be the privilege. So it's not, you cannot just defend the perpetuity of this tax regime. It should not be applied for the rest of the lives of the agreement. So we can say that the taxpayer who did the tax that was required under the current legislation should have this or that behavior that which is protected under the law, even though there is a new law. So they can say the applicable law in this case is the one when the moment of the test was run, and the result may be different under other circumstances. This is another one which is a little bit more complex. And it involves another option that was available under the previous legislation. So when a taxpayer imported a piece of equipment, and then under the previous legislation, there was another rule that Fabian explained, which was the best method, the best adequate method. So the taxpayer in that procedure of importing a good decided to use the PRL method. So they should bear the costs of having to test that adequation every year. Not at the initial moment. The test was just when you're going to resell the good because there was depreciation of the machine, and then you had the result that generated an expense for the company, and that expense was in stock and also reselling. And every year, the taxpayer that had opted for that had to test based on the PRL whether that expense was really appropriate to that expense that occurred years before. So the option would just postpone the test for the moment of the operation. Now there is a new law that was enforced from 2024, there is a new PRL with a new criteria. And the question is, should I apply the new law in the previous years, such in 2024, when the test is done, for you to determine how adequate the price transfer or the transfer pricing is? The first assumption to this case is that the result is different from the previous one. In the previous case, the test was run in the moment when the loan contract was signed. In this situation, the previous regime established that the test should be run afterwards, which is already established in the new law. So every year, starting 2024, you must run the test. But now there are other situations. Which is the method to be used in starting 2024? I had chosen PRL back in 2022. Now I have a new PRL under the new law. And now we have a new rule saying that I cannot choose the method. I have to use the one that is most adequate. So the first hypothesis for this is, here, there is no retroactivity to the law because the law applies to future taxes, and as you apply to those future taxes the criteria of the new law, including the best method of choice. Because these best choice should not be PRL, or could be TMM. So this shows, and this also leads me to another preliminary assumption, that we have to look at each one of the situations to see what was the choice under the law that was effective at the time for that type of operation related to the price of the transfer price. And then we have to see whether there is a retrospective effect to that good, or if the new law is effective without any other kind of mitigation. So this is what I had to share with you. I think that I could cover this within my time. I think that these issues is something that really bothers all of us and makes us very concerned. Thank you. I would like to thank Professor Gustavo. I think that all the issues raised are ones which we see every day, and they must be discussed because actually there is a transitional regime, and of course it also causes lots of doubts to our taxpayers. And now again I would like to pass the floor back to Professor Marcelo for closing of this panel. I just would like to say that we have received 3 questions, but because of time constraints we cannot answer them. I just want to tell you a secret. In our Q&A, you know, Claudia Pimentel also accepted the invitation, or last minute invitation, to answer the questions. So, to participate in the panel. So she can answer those questions later in that session. Good. So we have a super expert participating in the panel. So just keep your question to that last session. So, okay, so Professor Marcelo, can you please close the panel? And thank you very much, all the panelists, because the level here was really very high. Thank you, everyone. I was hearing all of you and all the inputs, and I just would like to highlight a couple of questions, a couple of issues, like country risk. To Fabiana, the Mandarin is the economist that publishes the rates. We tested the formula because we didn't know whether it was JP Morgan or Mandarin, but those who operate in China knows that they are operating there. Professor Fabiana said something good. She mentioned an article that says that if you come to Brazil and you ask to raise the risk because you want to operate in that country, so you have to deduct that risk from the advantages of being here in Brazil because of less protection, lower taxes. So there are people or professors who defend that country risk should not even exist, even though there is no guideline to it. Another interesting aspect is aura. In the previous panel, we had several inputs on the arm's length principle, and this panel is between Germany and Brazil in a soccer match. And there are several theories that are raised. Ora is the principle of legality. Ora is the constitutional assurance. And ora is a legal assurance and protection, the freedom of contraction. So we can have a series of new theses to be produced and papers that can result from this debate. Thank you very much for everyone. It was a very good panel. And now we have a break.